I made some statements in my rambling while ambling video this morning that some people have misconstrued. Some have done that honestly, and others have done it less so. But there's a couple things that I want to address. You can choose which of the two you think this particular person is. But I'm going to start at the bottom, and then I'm going to go up to the top. This person says, just because the Constitution says it, and he's quoting me, doesn't mean that it has any actual meaning, end quote, is probably the dumbest thing you've said to date. And then he goes on to try to read my mind. Now, there are things in the Constitution that are there, but don't have any actual legal meaning. Take, for example, a well-regulated militia being necessary to the security of a free state. You may recognize that from the Second Amendment. That has no legal meaning. How do we know it has no legal meaning? Because in District of Columbia v. Heller, Justice Scalia, writing the opinion, said it doesn't have any legal meaning. He says it is a prefatory clause. The former does not limit the latter, but rather announces a purpose. All it does is say why you have the right to keep and bear arms. It doesn't give you any rights. It doesn't take anything from you. It just says why you have the right to keep and bear arms. And then, of course, he goes on to find a completely different right why you have the right to keep and bear arms, and that would be for self-defense. And he says that you could rephrase it as, because a well-regulated militia is necessary to the security of a free state, and then you get into the meat of it, the right of the people to keep and bear arms shall not be infringed. So it is in the Constitution, and it has no legal meaning. And so smart people know what they're talking about. And then there's this particular quote here, free press, meh, don't worry about that bit. It doesn't fit my narrative. And I believe what he's trying to paraphrase, although I'm using trying to paraphrase very loosely, because obviously he's trying to straw man, because, well, that's what you do if you don't have any good arguments. The press, it doesn't just, because the Constitution says it doesn't mean that it has any actual meaning. Just because the Constitution says it, doesn't mean it has any actual meaning. That's the sentence. And I think it doesn't have any actual meaning because to date, the court has found that all the protections, all the protections required for the press are already wrapped up in the freedom of speech, because the press is basically just publishing its opinions and facts and things like that, so there's no real need to create any special exemption for them, because it's already just freedom of speech. So is Finbar wrong? No. He wasn't wrong. He wasn't particularly right, but he wasn't wrong. And what am I saying? What am I meaning by that? So here's Florida Star v. BJF. This is a famous case about a newspaper, and it actually mentions freedom of the press. But what is it actually about? Florida Star, a newspaper, published the name of a woman, BJF, who was sexually assaulted. And they got the sheriff's department put her information out to be published in the press room, whatever that is. And so they published it, and it violated a Florida statute. The Florida statute makes it unlawful to print, publish, or broadcast in any means or in any instrument of mass communication the name of the victim of a sexual offense. Now, it doesn't limit it to newspapers, and it just is unlawful to print, could be in a book, publish, could be in a book, or broadcast, could be on a network TV show, it could be on a news show, it could be on a podcast, or obviously this was before that kind of stuff, but it could be on the internet, could be on the radio, could be on a talk show, we don't know. In any instrument of mass communication. the name of victim of a sexual offense. And the Supreme Court struck this down, but it's violating. Well, so it said it actually made a little exception for newspapers. If a newspaper gets it legally, they can publish it, but that goes for everybody. If you get something legally, you can publish it. Then there's Gertz v. Robert Welch. So there's no difference between you and a newspaper in this. This statute would have affected your right to print, and the exception carved out, in air quotes, for newspapers also applies to you. And there's a real reason for that. So freedom of the press is freedom of the printing press, as well as freedom of the newspapermen or reporters. But the thing is that newspapers publish speech. So if it affects the newspaper, it affects speech. You know, there's the op-eds. That's where people put their speech. An article written by a journalist is that journalist's speech. It doesn't matter that he's a journalist. I mean, you don't have to get like accredited to be a journalist. Anybody can write an article. It's just speech. And it's protected by speech. Gertz v. Welch. This is just the communication of the New York Times v. Solomon line of cases. Defamation and libel. Newspapers don't have any greater protection against defamation and libel than you do. If you, defamation, slander and libel, if you print something on the internet, or if I make a video that is libelous against a public figure, I'm not a reporter. I don't even play one on TV. But I would still have the New York Times, the actual malice line of defense. The newspaper doesn't have any greater or worse protection than I do, and the whole line of reasoning for this goes back to freedom of speech. Freedom to publish your opinion. Sometimes you're going to, in trying to protect free speech, sometimes you're going to have to allow a little bit of, or in trying to allow the truth to be spoken, sometimes you're going to have to allow some lies to come in. You just, you know, there's always that little gray area around the edges. Brandsburg v. Hayes. This is where the journalist tried to claim First Amendment protection to not reveal his source from a grand jury. And the court said, no, there's no special protection for you. And yeah, we get it. If you have to reveal your source, then that could cause your sources not to want to talk to you. But you can't ignore the grand jury just because you don't want to divulge your source. And then finally, there's Hazelwood School District v. Kuhlmeyer. Hazelwood School District v. Kuhlmeyer, the students wanted to publish articles about a divorce and sexual activity and birth control. There we go. And the school principal said no, and so the school kids sued because, you know, they wanted to publish. And sorry, you're in school, so you don't have any greater rights of speech because you're putting it in a newspaper. You don't have any greater protections to your freedom of speech just because you're trying to put it in a newspaper than you would if you were just saying it. So what I'm saying is that there's nothing different or special about the press. They have exactly the same freedoms of speech and freedoms to publish as you do, as I do, as every other American does. I'm not trying to insinuate that I don't want a free press. I'm saying they have just as much protection to freedom of their speech as you have, as I have, and I am very keen on freedom of speech, which is why I let Nigel Lovelace puke this garbage all over my comment section. I have never once removed any of his comments or deleted him or hid him or anything like that, because I value free speech. I value free speech for everybody, which is why I value the First Amendment. My actions speak louder than my words. Thank you for watching. Have a great day.